So let's continue. So this is now rule 2 with regards to to the 2019 civil procedure. Okay. Section 1 of rule 2, this is cause of action. This is the start, okay? This is the start of everything in terms of a civil case. So we will define first. Section 1, ordinary civil action, the basis of every ordinary civil action must be based on a cause of action. So everything, every civil case, the basis of is there should be a cause of action. Okay. So what is a cause of action, section 2? So a cause of action is the act or omission. Remember, an act or omission by which the party violates the right of another. So that is an external act. In claim 1, di ba, there's always an external act. Okay? So if you do it, or if you did not do it, uh, there is a cause of action with regards to maybe a contract of not doing. And oblicon, we mentioned that it is what? It is a prestation of to do, not to do, and to give. To give, not to do, and not to do. Okay? Ah, kasi magkadikit ang oblicon at ang civil procedure natin. Okay? Because the all of the things with regards to the substantive laws, which is oblicon, succession, property, are now being uh, enforced on the civil procedure when it is a civil case. Okay. So, Section 3, one suit of a single cause of action. One suit for a single cause of action. So, this is 1:1. Okay. A party may not institute more than one suit for a single cause of action. Next, Section 4, splitting a single cause of action. The effect. If two or more suits are instituted on the basis of the same cause of action. Remember, parang this is uh, many many is to one, di ba? Parang in engineering, we have one is to many principles, right? So, in this section, if we split, it's like dividing, di ba? Pero dividing what? One single cause of action. Okay? So many is to one. Okay. Okay. If let's read again. If two or more suits are instituted in the same, okay, on the basis of the same cause of action. Okay. So the filing of one or the judgment upon the merits is in anyone is available as a ground for dismissal for the other. Do you understand? So it can be a ground for dismissal with regards to the other suit. So when we split, it becomes uh, a ground for the other for a dismissal. There is also a concept of a jointer. Okay. So uh, the other one is we split. In section 5, we join. Okay. So what is a jointer? Jointer of causes of action. If a party may in one pleading assert in the alternative or otherwise as many cause of action as he may have against the opposing party subject to the following conditions. Okay. Number 1, the party joining cause of action shall comply with the rules of jointer. So there is a rule of jointer. So you can join the parties, okay? Uh Maybe that will be discussed on the other rules. Number 2, the jointer shall not include special civil action. Remember, special civil action. We are just discussing ordinary. Okay? Let's underline. Or actions governed by special rules. Okay? Number three, where the causes of action are between the same parties, but pertain to different venues or jurisdiction. The joinder may be allowed in the regional trial court, provided one of the causes of action falls within the jurisdiction of the said court and the venue lies therein. And fourth, where the claims in the causes of action are principally for the recovery of money. The aggregate amount claimed shall be the test of jurisdiction. If you look at section 5 dot C and dot D, this is all about jurisdiction. Okay, we will do an illustration later. So section 6, misjoinder. So napansin nyo, there is a cause of action. We can also split it. We can join, but there is what? An exception. The exception is a misjoinder of the cause of action. Misjoinder cause of action is not a ground for dismissal of an action. A misjoined cause of action may, on motion of a party or on the initiative of the court, be severed and proceeded separately. Okay. So, not a ground for dismissal, but it can be decided separately. Okay. This is our notes with regards to Rule 2. So, important principles. The act or omission which violates the right of another. Note, cause of action is the act or omission. It is not the right violated. Remember, cause of action is an act or omission. The cause of action is what? This is a remedial law concept. The rights violated is in the substantive law, which is that's either in oblicon, succession, property, or maybe crim one, criminal law also. Okay, let's do an illustration. Question: Mr. A did not pay his debt to Mr. B upon demand. What is the cause of action? What's the right violated? Okay, the cause of action is the failure to pay. The debt upon demand. The right violated is the right of the creditor to be paid. Okay, ulitin natin. The cause of action is the failure to pay the debt upon demand. What did Mr. A did? Mr. A did not pay his debt to Mr. B upon demand. So there is a notification, a demand letter. Okay? Remember, there's a demand letter. It's either what how do you now define a demand? That is either judicial or extrajudicial. When say extrajudicial, normally there's a demand letter. So Mr. A did not pay. So the cause of action is the failure to pay the debt upon the demand letter. So what's the right violated? The right violated is the right of the creditor to be paid. Baliktarin lang natin. So sometimes it's just about the choice of words. So when he says positive, we will now say it as negative on the other spectrum of our answer. So next would be one cause of action may give rise to several reliefs. Question. Mr. A stabbed Mr. B. How many causes of action does Mr. B have? How many relief does he have? Mr. B has one cause of action against Mr. A because there is only one act. of stabbing that violated the right to be alive. However, he has multiple reliefs against Mr. A, such as actual damages, moral damages, exemplary damages, and so on. Next question. Mr. A forcibly entered the real property of Mr. B. How many causes of action does Mr. B have? How many relief does he have? Mr. B has one cause of action against Mr. A, since there is only one act of forcible entry. It's underlined. That violated his property right. However, he has multiple reliefs against Mr. A, such as the recovery of possession, the recovery of unpaid rent, and damages. Mr. A occupied a parcel of land which was allegedly untitled. Later, Mr. A was able to obtain a title to the land under his name. Later, Mr. B filed two actions against him, which are one, action for the conveyance of property, and two, action for ejectment. Mr. B filed the first action because he alleged that he has an original title of the parcel of land. Meanwhile, he filed the second action because Mr. A has no right to enter into the property that he owns. Did Mr. B split a single cause of action? No, because there are multiple causes of action. The act that allegedly violated the right of possession of Mr. B was different from the act that allegedly violated his right of ownership. Thus, there was separate causes of action. This is in De La Cruz versus CA. So, what's the subtopic? One cause of action may give rise to several reliefs. Next would be one cause of action may give rise to several uh, parang mali tayo dito ah. Okay, let's go to the question. Mr. A bumped the car of Mr. B, causing physical injuries to Mr. B's person and damages to Mr. B's car. How many causes of action are there? How many rights were violated? There is only one cause of action. There was a single act of bumping, however, multiple rights of Mr. B violated, such as the right to be safe in his person, in his property right. Mr. A kicked Mr. B. How many causes of action are there? How many rights were violated? There is only one cause of action, which is the single act of kicking. However, multiple rights of Mr. B were violated, which are his right derived from quasi delict and his right derived from civil liability ex delicto. Next would be one cause of action may give rise to alternative remedies. In this example, a loan contract may be different from mortgage contract. However, both refer to the same obligation, which is the unpaid debt. Thus, the creditor mortgage has one cause of action against the debtor mortgagor, which is the non-payment of debt. This gives rise to two alternative remedies of the recovery of debt, which are to file a collection of the sum of money and to foreclose the mortgage security. A remedy is deemed chosen upon the filing of the suit for the collection or the suit for foreclosure. Choosing one remedy bars the creditor from availing for another remedy. In Madilag versus Martinez. If a criminal charge under BP 22 was filed against the dissolver of the check, can the creditor still file an action for collection of sum of money or judicial foreclosure later on? Yes, the court ruled that the filing of BP 22 case is not the collection suit contemplated by law, which bars the mortgage from later foreclosing the mortgage property. The court explained that the intention of the law is to make the mere act of issuing a worthless check malum prohibitum and prejudice or damage to the offended party is not a prerequisite to conviction. Spouses Torres versus Medina in 2010. Next would be contracts with numerous stipulations. So the general rule, a contract embraces only one cause of action because it can only be violated once, despite having several stipulations. Note, only one thing or act was done to violate the contract. Example, a contract of loan was secured by a real estate mortgage. There are several stipulations in the contract. If the debtor fails to pay the first month of the amortization upon demand, there is only one cause of action, even though the contract has numerous stipulations for the loan and the mortgage. Exception, a contract to do several things, acts of acts or several times, is divisible in nature. Hence, it may give rise to several causes of action. Note, several things or acts were done to violate the contract. Example, in a contract of loan of real estate mortgage, Mr. A failed to pay the installment due to Mr. B for the second, fifth, and 10th month of the contract. How many causes of action are there? There are multiple causes of action. Once Mr. A fails to pay the second month of the contract, Mr. B can file a suit. Once Mr. A fails to pay for the fifth month, Mr. B can file another suit, and so on and so forth. However, Mr. A can join all of these causes of action in one suit. Example, 10 installments were already due and demandable. This also applies to contract of lease. Mr. A leased a residential apartment from Mr. B under the contract. Mr. A must only use the apartment for residential purposes, and the rent paid is 20,000 per month. After 1 month, Mr. A used the apartment for business purposes. After 5 months, he failed to pay the rentals for the property. How many causes of action are there? There are two causes of action because Mr. A had to perform several things at several times. He must pay 20,000 every month, and he must only use the property for residential purposes. However, Mr. A can join all of these actions of causes of action in one suit. Okay. So exception to the exception, this is the doctrine of anticipatory breach. So when we say anticipatory, you're anticipating there would be a breach of contract. Okay. Under this doctrine, if the obligor manifests an unqualified positive refusal to perform the whole contract, the injured party can only bring one action, even though the performance of a portion of the contract is not yet due. In such case, all the installment due to the at the time of the filing of the suit must be included. Failure to include any installment due bars its collection. We have to note that the facts must show that the defendant already refused to perform the whole contract. If it shows a mere failure to perform the contract, the exception applies. Example, in a contract of lease, Mr. A already texted Mr. B that he will not pay the rentals due for the remaining months of the contract. At the time of the filing of the complaint, 5 installments were already due and demandable. How many causes of action are there? There's only one, because Mr. A already manifested that he will not perform the whole contract. Thus, all the installments due at the time of the filing of the suit must be included by Mr. B. Example, all of the 5 installments that were due and demandable. Failure to include any installments bars its collection. Why? Because another action of unincluded installment would result to splitting the causes of action. Next would be failure to state cause of action versus lack of cause of action. The first situation where the complaint does not allege a sufficient cause of action is raised in a motion to dismiss under Rule 16 before a responsive pleading is filed and can be determined only from the allegation of the initiatory pleading and not from the evidentiary or other matters alyonde. The second is situation where the evidence does not sustain the cause of action alleged is raised in a demurrer to evidence under Rule 33 after the plaintiff has rested his case and can be resolved only on the basis of evidence he has presented in support of his claim. The first does not concern itself with the truth and falsity of the allegation, while the second raises precisely because the judge has determined the truth and falsity of the allegation and has found evidence wanting. Dumondon versus Lopez. So, failure to state the cause of action and versus lack of cause of action. So, on failure to state the cause of action, there is failure to state cause of action when there is insufficiency of the allegation in the pleading. The ground must be raised as an affirmative defense in the answer. Failure to do so shall constitute a waiver thereof. The dismissal is without prejudice and can't refile. Okay? So it can be refiled. So lack of cause of action. There is lack of cause of action when there is insufficiency of the factual basis of the action. On Swagman Hotel versus CA, the evidence does not sustain the cause of action alleged. So what is that? So if you look at the failure to state cause of action, in there is already an insufficiency with regards to the initial pleading. So what's the initial pleading? That is the complaint. But when we look at this, when we relate it to the lack of cause of action, it says that there is a lack of cause of action when there is insufficiency of the factual basis of the action. So there is already a reply. Okay. So the evidence, there is already an evidence that is being presented to the court. And the evidence cannot sustain the cause of action being alleged. So may kulang. So uh, when there is now a presentation of evidence, now there you now can we can now understand that there would be a lack of cause of action. Okay. So the lack of cause of action is the ground of lack of cause is raised in a demurrer of evidence under Rule 33 after the plaintiff has rested his case. So, saan tayo papasok dito? So, it is in the trial already. Okay? The dismissal is with prejudice and you cannot refile under Lex Judicata. So we will discuss later how this is being dismissed. It's either being by uh, litis pendentia or Lex Judicata. In lack of cause of action, it is what? Lex Judicata. So here are some illustrations. Mr. A did not allege that he sent a demand letter to Mr. B. However, he actually sent a demand letter to Mr. B. Should the case be dismissed? Yes, for failure to state cause of action. So the dismissal can be stopped on that one. Mr. A alleged that he sent a demand letter to Mr. B. However, Mr. A never sent a demand letter to Mr. B. Should the case be dismissed? Yes, for the lack of cause of action. Mr. A alleged that he sent a demand letter to Mr. B. However, Mr. A never sent a demand letter to Mr. B. Should the case be dismissed? Yes, for the lack of cause of action. So we goes to splitting. Splitting of a single cause of action. Splitting a single cause of action is the act of instituting two or more suits for the same cause of action. Section 4, Rule 4. Okay. In such case, the filing of one or the judgment of the merits in any one available as a ground for dismissal for the other. The proper ground for dismissal is either litis pendentia or lex judicata. So section 12, rule 15. So however, if there is a willful deliberate forum shopping, all actions shall be summarily dismissed by the court with prejudice. Remember, forum shopping, every time you have in the new rules of court, there should be a certification in terms of forum shopping. So what is litis pendentia? So litis pendentia, the requisite for this is we need to have the identity of the parties. For both plaintiff, defendant, it's either co-defendant or a third party also. So we need to also to have the identity of the rights asserted and release prayed for. So what is that? That is the cause of action. And lastly, identity of the two preceding particulars, such that any judgment rendered in the pending case would amount to lex judicata in the other case. So this is in Philippine College of Criminology versus Bautista. So one, identity of the parties. It merely requires substantial identity, not absolute identity. Substantial identity means that there is community of interest, a privity of interest between a party in the first and a party of the second case. If the first case did not impede the latter. Question. In heirs of Trinidad de Leon versus CA and Magueson, the heirs filed an action for annulment of the registration of two unregistered lots against Magueson. Later, in Maykawayan, as the buyer of the lots from Magueson intervened in the action, the heirs won with finality. Thus, the OCT in the name of Magueson were cancelled and new titles were granted in favor of the heirs. Later, Mike Kawayan filed an action for reconveyance against the heirs. Was the identity was there identity of the parties? Yes, absolutely. Absolute identity is not required. Substantial identity is only required, which provides that there must be community or privity of interest between the parties in the case. Here, Mike Kawayan is the only successor of Maqueson. So there was community of interest between them. So the cause of action is the basis for invoking the second requisite. Example, rights asserted and release prayed for. Identity of causes of action does not mean absolute identity. The test is whether the same evidence would support and sustain the first and second action. This was seen on the Philippine College of Criminology versus Celia Bautista Lim versus Bautista. This is also called as the same evidence test. So, question. Uh, in Riviera Golf Club Incorporated versus CCA Holdings, Riviera Golf Club pre-terminated the agreement with CCA with state which states, among others, that CCA will manage the golf club of the Viela Golf Club in exchange of management fees. In 2001, CCA Holdings filed an action for sum of money with damages against the Viela Golf Club for non-payment of management fees. Later, RTC dismissed the case based on the compromise agreement of the parties in 2002. Another action was filed by CCA Holdings for a sum of money with damages against the Golf based on the premature termination of the agreement. Was there identity of causes of action? Yes, both cases were based on the same imputed act, which was the alleged violation of the agreement. Using the same evidence test, there was glaring similarity on the documentary evidence submitted to prove the claim. The evidence in the collection of the unpaid management fees and the recovery of damages for the expected business profits profits aim at establishing the breach of the management and royalty agreements. Thus, there were identical causes of action. This is splitting. Split is potential. Okay. So next example, Mr. A lent 10 million to Mr. B, secured by a real estate mortgage. Later, Mr. B failed to pay upon demand. So Mr. A filed an action for collection of sum of money against Mr. B. 1 month later, Mr. A filed an action for judicial foreclosure against Mr. B. Was there identity of cause of action? Yes. Both cases were based on the same act, which was Mr. B's failure to pay the loan demand using the same evidence test. The pieces of evidence that will prove Mr. A's right to be paid are similar to those that will prove his right to be uh to foreclose. Thus, there were identical causes of action. In the Philippine College of Criminology and Cecilia Bautista Lim versus Bautista, respondent Bautista was ousted from being president and board chairman of the college. Petitioner Cecilia Bautista Lim replaced him. Thus, Bautista filed two successive actions. First, a petition for quo warranto, and the second, an action for specific performance. The first case sought petitioner Cecilia ouster and respondent Bautista's restoration as president of the board and chairman of the college. In the second case, respondent Bautista sought his restoration as a board member. Both actions are based on the same act. The petitioner's non-compliance with the certificate that they executed, the certificate provide that they will comply with the order of the former president of the college, Mr. Eduardo Sr., who stated that in the case he dies, respondent Bautista will become president of the college. President and board chairperson of the college. Was there identity of cause of action? Yes, both cases were based on the same act. Failure to comply with the certificate that they executed. Further, the pieces of evidence that will be presented for the coral warrant petition and the action for specific performance are the same. Thus, there are identity of cause of action. So, litispendentia versus willful and deliberate photo shopping. So, as mentioned earlier, the certificate for fraudulent shopping is needed in every case. Okay. So in both instances, the court shall motu proprio dismiss the action. In both instances, the requisite are the same. But for willful and deliberate fraudulent shopping, we have to add willfulness and deliberateness. Both defenses are non-waivable and can be raised at any stage of the action. However, for litis pendentia, not all of the actions will be dismissed. One will remain. For willful and deliberate forum shopping, all will be summarily dismissed with prejudice. For willful and deliberate forum shopping, the facts must show that the party intended to the multiple suits for one cause of action. If the facts do not show that, the ground is only for litis pendentia. So we'll end the video. This is the first part for rule 2, and then we'll do another part for rule 2, startings from Rex Judicata. Thank you.